Ahora hay que conectar el Skype.
Sí, sí, sí. Ahora es que lo van a
¿Activado el micrófono?
Ese es suyo, creo que
presentación.
y él aparece, y él está ahí también.
First presenter is Pablo. So we
Skype.
Somebody from the, of course. I just copy my. I finished. So
Okay.
I only have to put out my
okay.
pen drive.
Just
So.
do whatever you need to.
Okay.
But do not close that.
Okay. So.
Well, I'm going to be very
Yeah.
with the time, so because we don't have a lot of time. So.
Please
Now
don't
it's
remove
everything.
one.
Okay.
Thank
So
you.
I will sit on my place.
Me imagino que quiere que cargamos las diapositivas.
Bueno, pero a él se lo puede hablar. Él está abierto. Vale, vale.
Could I borrow from you one piece of paper to note the eventual questions?
Take one.
Thanks.
Pablo, Stuart sitting here. Y no lo vamos a ver.
No, vamos a
Bueno,
ver.
está ahí. Está ahí, pero vamos, que está escuchando y que es el único que habla.
Okay.
Pero,
I have to move.
It's your code.
yes, but I can move if you want.
Where is she sitting? She's sitting here.
Okay, just set a chair.
Yes, but if you want, I sit there if you prefer. For me, no problem.
The chair is sitting here.
Yes.
Ah, now I understood. Now I understood.
The chair is chair for the sitting here.
Yes, you are more comfortable.
You want water?
Empezamos.
So, one more?
Okay, thank you.
La diapositiva del Skype. No sé bien.
Okay, thank you.
You're welcome.
No, es que estoy mirando la presentación, la única de la presentación. Solo un minuto.
O sea, no vamos a ver la presentación.
Sí. Puedes empezar.
Voy introduciendo y... Well, good afternoon. Well, this is the first panel of this afternoon, and this panel is about social rights, although, as we will see, there are different topics around social rights. So we are going to follow the program, except in the first presentation, that is the one of Pablo Sartorio, that is from the University Carlos III, but nowadays I think he's in the United States, so he is the first one who is going to present his paper through Skype. I am going to ask you that please be very strict on time, because there are a lot of presentations and well, it's interesting after that to have some debate and some discussion of your papers that are all very interesting. I can advance.
What's your limit?
12 minutes.
Okay.
Okay.
You
Okay.
have to watch us.
Yes. So, Pablo, can you listen us? Or
Yes, I hear you.
okay. you can start when you want.
Well, good afternoon, everybody in Madrid. Thank you for giving me the opportunity to be part of this conversation. My name is Pablo. I'm a doctoral candidate with the Universidad Carlos III, and I'm currently carrying out part of my research in the United States. Slide.
I think no. Well, I think there is a problem with the PowerPoint, Pablo. So wait.
Yeah, I sent the PowerPoint in advance, and
now we see your PowerPoint, but we don't see you.
A version of it. Okay. The next slide, please. Today I'm here to talk with you about a subject that is very close to my heart, the rights of those behind bars and how they pay their debt to society. As a public defender in the United States, I have served those who didn't have anyone else. Public defenders are paid by the state, just like prosecutors, and their only job is to represent the indigent in criminal court. I had a caseload of approximately 350 plus open cases at any given time. So needless to say, time was always of the essence. Some of those I served have done very bad things, but many just happen to be in the wrong place and the wrong time, or just plain innocent. We're going to talk about incarceration in the US. What is it like to be in prison? And what world is awaiting for you when you come out? All keeping in mind whether we're complying with human rights along the way. Slide. Any society, any nation is judged on the basis of how it treats its weakest members, last, the least, the littest. As a society, do we make sure they serve their time following human rights? Do we give prisoners the necessary tools to become active members of our communities? Let's take a look. Slide. Among other things, the US is known to be the biggest incarceration in the globe, keeping close to 2.5 million people behind bars. In the US, you're 97% more likely to serve more than 1 year in prison. But that's not all. When we add the supervision prisoners must undergo after leaving prison, which adds years more, the numbers of individuals under the control of the criminal justice system is just north of 6.5 million people. Just to put this into perspective, the Madrid metropolitan area is estimated to be about 6.5 million people. Being the third largest metropolitan area in the European Union, this is how much people the US have behind bars. Slide. The one before. Most people in the US worry first about safety and the cost of all this. So let's review. In personnel alone, the US has spent almost $43 billion a year. Depending on the state, the cost of prisoners reaches levels equal to a middle income salary of $60,000. And every resident contributes to this cost with approximately $132. After paying all this and locking all these people up, can we say for sure that we're any safer? Well, research has shown that the answer is simply no. But to understand whether prisoners come back to our communities with all the tools they need, we need to take a look at what occurs in prison. One second. In prison, every aspect of your life is carefully monitored. You're expected to follow the rules, period. Consequences to any deviation include solitary confinement, which research has shown to have a devastating effect on mental health. Treatment and education are not readily available, despite the common belief. And as prisoner, you're likely to be transferred around to different states, putting a serious strain on family relationships, in some cases making them disappear. Considering all this together, it is impossible to expect anyone to come out of prison without any issues. And it's doubtful that these conditions pass the human rights test. Leaving prison does not necessarily end the problem, because this debt continues to grow beyond the walls. As a felon, the first step you take out of the door comes with more challenges. Depending on how long you serve, it is most likely that you have a hard time adjusting to the community without fear of being hurt, just like it was in prison. As a felon also, you're going to have a hard time finding a job without getting through a background check. Same for housing, public benefits, or social services. So now, not only you don't have a job, you don't have a place to live, there's no help from social services, and you have less than 30 days to pay for supervision. If you don't comply with any of this, the consequence is that you're going back to prison. So what's wrong with all that? Well, it really depends what kind of society we want to be. Not everyone behind bars is bad. Some have done horrible things, but there are many redeeming qualities in them. When you look closely, you'll find people who truly want a second chance and just some help. Which brings me to the case of Marcus, one of thousands of clients I have represented over the years, and one of the most memorable, because of the power that leading with compassion had in his case. Marcus was a troubled young man who lived in a very hard life, which began all at the tender age of 18 months. His case came to me as a public defender. The evidence was against us, and so were the facts. I suggested to Marcus that the only hope that we had was to plead guilty and ask for treatment and probation as sent.
Thank you very much.
Oh, now I hear you.
Acho que ele não te ouviu da primeira vez.
He
He
can.
doesn't hear you.
You cannot. No, I say that if you can, if you agree, we are going to present the rest of the papers, and after that we are going to ask the questions to your presentation and the other of them. If you can stay online, listening through Skype. I don't know if that is okay for you.
Yeah, absolutely. Go ahead.
Thank you very much. Okay, thank you. Well, the second paper is titled, Do the Same-Sex Couples Have the Right to Marry under the Rules of the Universal Declaration of Human Rights and the Constitution of the Republic of Poland from 1997, and is written by Professor Tomasz LITWIN from Jesuit University Ignatianum in Krakow, Poland.
Okay. So I can take the stage, yes?
Yeah,
Okay.
thank you very much.
Thank you very much for introducing me. Good afternoon, ladies and gentlemen. And I would like also to thank organizers for inviting me for such great scientific event. So let's now start the presentation. I will focus only on the main issues because of the time limits. So let's start with the Article 16, paragraph 1 and 2 of the Universal Declaration of Human Rights. As it is clearly visible, men and women, adult, without any limitation due to race, nationality, or religion, have the right to marry. The main condition requirement to exercise this right is the free will of the intending spouses, as it is clearly written in the paragraph 2. And what's more, the spouses have the equal rights also concerning the act of marriage, the living during the marriage, but also the dissolution of marriage. If I would like to answer the question if this Article 16 also concerns the homosexual couples, and I feel that it is necessary to make the systematic interpretation of the UDHR. So as it clearly visible, the Article 1, 2, and 7, we can found the general principle of the equal position of homosexual persons and heterosexual persons. As it is clearly visible, the article first is about all human beings, which definitely means the homosexual persons and heterosexual persons. Also the term everyone is concerning the homosexual persons and heterosexual persons. So the same is with the Article 7. Therefore, the Article 2 states that everyone is entitled to all the rights and freedoms forth in this declaration. So all people are entitled to exercise the right to marry without distinction of any kind. And here is the list the list, the detailed list doesn't concern the sexual orientation. However, there is a term other status. So this term other status could also mean the sexual orientation. And Article 7, there's a general prohibition of the discrimination. Therefore, by the systematic interpretation of the all articles, we can get to the conclusion that the homosexual couples and heterosexual couples have in the same degree the right to marry as the other status. So the sexual orientation cannot be the reason of any kind of the discrimination or limiting the rights or freedoms which we could find in the declaration. But what about the term that was used, the phrase that was used in the Article 16, men and women? Does it limit the right to marry only to the heterosexual couples? Well, there wasn't any official interpretation of the Article 16 of the UDHR. However, in the case Jocelyn versus New Zealand, United Nations Human Rights Committee made a judgment concerning the Article 23 of the International Covenant on Civil and Political Rights, which also concerns the right to marry. And the committee stated that the term men and women used in the article, used in this article, instead of such terms as every human being, everyone, or all persons, limits the marriage only to the union between man and woman wishing to marry each other. Well, I cannot agree with such interpretation because that is the strictly language logical interpretation of this rule, and oppositely we can say that the Article 23 does not explicitly prohibit the same-sex marriage, because if the lawgiver would like to limit the right to marry only to the heterosexual couples, he would use the term persons of different sex instead of the men and women. What's more, if we analyze only from the linguistic perspective the term men and women, we would say that it means two or more men, two or more women, or some combination of the number of men and women. The Article 18 of the Polish Constitution states that marriage as a union between man and woman. Please note that here the rule used the singular form. So, one man and one woman. My research concerning this article, this rule of the Constitution, because it was the source of some controversy among constitutional legal experts in Poland, lead to such results. Does Article 18 of the Polish Constitution prohibit same-sex marriage? The language logical interpretation of this rule well, leads to the answer yes. Also, the same answer will be result of the teleological and historical legal interpretation, but the systematic interpretation of the rules of the constitutional of the rules of the Constitution of Poland from 1997 would lead to the answer no, because generally we could find the rules that will allow us to make the hypothesis that homosexual and heterosexual couples in Poland have the equal position and equal rights. However, in the Constitution we can find the rules that could be interpreted as discriminative. What are these rules? I think you can find these rules also in other constitutions. They concern the age that allows to start in the elections, especially parliamentary elections, presidential elections, which require the higher age than adult to start in such elections. Of course, it's some kind of the legal tradition. However, there is no, nowadays, I think, rational justification of such rules. Therefore, the Article 18 could be regarded as the exception from the general prohibition of the discrimination from the rules of the Constitution, of the Polish Constitution, that concerns the sexual orientation. Also, the judicial interpretation of the rule is not clear, because the Constitutional Tribunal in its verdict from 2004 stated that Article 18 prohibits same-sex marriage, but last year the Voivodeship Administrative Court stated that it doesn't prohibit. Well, in my opinion, the more relevant is the verdict of the Constitutional Tribunal, as it was directly concerning this legal issue. Therefore, in my opinion, the Article 18 of the Polish Constitution prohibits the same-sex marriage, and Article 16 and the rules of the UDHR concerns right to marry to the same-sex same-sex couples as well as the hetero couples. However, I think that my interpretation, especially of the UDHR, has no chance to be supported because of the clear political reasons, I think. I also don't think that there will be any change concerning the possibility of introducing the same-sex marriage to the Polish legal system. And I think it's a shame, because I think that the states should support the love of their citizens, no matter if they are heterosexual persons or homosexual persons, because as 4 young guys from the Liverpool sang in the late 60s, all we need is love, and love is all we need. Thank you very much.
Thank you very much. The next paper is titled The Ineffectiveness of the Constitutional Amendment number 81, 2014, and the deconstruction of the foundations of contemporary slavery labor in Brazil. And it's going to be presented by Elena Neves Manuez Correa de Melo, that is professor in Amazon University in Brazil.
Okay, good afternoon for everybody. I've been working. Okay. And I'm working this research for years, and this is my PhD thesis, and that I will present in August, I think. This is a part of the research. And I'm very happy to be here in Madrid, and I'm congrats for Professor Oscar. And I initiate my presentation. Okay, better. Alô? Alô? Alô?
Yes, I think so.
Tá falando?
Yes, I
Okay,
think it
okay.
works.
I begin my presentation with some photos of slavery, contemporary slavery in Brazil. These are real photos for taken in fiscalizations by federal policy. And so it's a reality in our world, so contemporary slavery, okay? But in Brazil, in Article 149 of Penal Code, we have a concept of contemporary slavery. And we are discussing here about the change of the law, the article, the text of Article 243, and the consequences of this changing, okay? So, in Article 149, Brazilian Penal Code, we have to reduce someone to the condition analogous to that of a slave, whether submitting it to forced labor, the exhaustive journey, subject it to degrading work conditions, or restricting by any means its locomotion due to debt contract with the employer or proposed. This is the conducts that are considered like contemporary slavery. So this is the law. And we have another proposal to change the Constitution in Article 243 to sanction case of contemporary slavery for non-compliance to the social function of property. Because in Brazil, a lot of contemporary slavery is found in farms, in rural spaces. So this is a way for eradicate or to try to eradicate this practice. But what happened with this amendment? This is the way. Okay, I can pass this. There can be no observance to the right of property, nor its guarantee if this right of property harms the human dignity and the rights through contemporary slavery, which is typified as crime on Article 149 of the Brazilian Penal Code, and is forbidden in every international human rights agreement Brazil has signed for. So this is the main reason. This is the main reason for try to change the Article 243 of Constitution, of the amendment, the 81 amendment. We have to, but what happens when the text is approved? The present amendment treats applicability, brings future regulation as a necessity as adjusted by the expression as set forth by law. And this expression, as set forth by law, in an interpretation that we have in Constitution in Brazil, this expression brings back the discussion over contemporary slavery, discussion about the concept of contemporary slavery, because that was already regulated in the terms of Article 149, like I showed before, of the Penal Code. Making the empathy of this concept possible is falling back to the understanding of years of this degrading practice. So if we discuss, discuss is not prohibited, but this discuss will be for empty the concept, the actual concept, you know, because a lot of, we have now a real possibility of retreat of this. This is the main consequence. Discuss of legal concept or create another legal concept, as set forth by law, can empty or could empty the actual concept of 149 penal code, and this will break and reduce the protection of dignity. This is the consequence. So we cannot go back into legal concepts. Cannot back into legal concepts with interpretation that don't protect dignity, human dignity. They are duly constructed and established from empirical and in-depth theoretical studies, which broadens the protection of dignity in favor of a kind of political discourse game. This is what my political reasons are influenced by big companies and owners in Brazil. So we saw that. And I get a lot of numbers in my research. So, which broadens the protection of dignity in favor of a kind of political discourse game with a mistaken interpretation of the legal elements in a clear intention to legitimize social inequality and the violation of human rights in Brazil. Okay, so this is my my work in a way, in a small way, no, show to you, because I have a lot of numbers, but I know that we don't have a lot of time. But this is the main discussion. We have a lot of movements in Brazil to break dignity, and these movements are complex movements, but led by politics and politicians and policies. Also, I thank you, and if you have any questions on the final, this is my.
Thank you very much. Well, the next paper is titled Social Rights in Europe and Free Platform Work, and it's going to be presented by Andrzej, Marian, I don't know if I am going to say correctly, ЩWIOTKOWSKI, more or less. Thank you. From Jesuit University in Krakow, Poland. Thank you very much.
Thank you very much, Mr. Chairman. I'm going to talk about the social rights and free platform work here, as our president said. So first of all, I have to simply say what it's all about. It's about first about the working conditions of the platform-based work. There is second, there is about legal status of workers, and the third one is about their social rights, which they don't enjoy any. That's out of the question. So I am just simply writing in this paper about the working people who don't know, as I said in a minute, any types of the social rights guaranteed by the European Social Charter. It's guaranteed by that act. It's just a constitution of the Council of Europe. And there is a revised European Social Charter of 1996, but we are also talking about the old Charter, 1961, which both Spain and Poland ratified, in the minority right now, which is not very proud information, but still it's okay. So those rights are written here in the Article 1, 2, 4, 5, 6, and the others, but I am talking about the most important ones. The Article 2, the right to just conditions of work. Article 4, the right to fair remuneration, really decent remuneration. Article 5 is about the right to organize. Article 6 about the right to bargain collectively. I'm not going to elaborate on this. If you are interested in what is written in the Charter and about my comment, I mean, 2 weeks ago, Walter Skluver published a book is entitled about the labor human rights. That's a labor law, Council of Europe. It's a third edition of this book. Walter Skluver is the author. So the next, since they do not enjoy, I mean, the second idea here is that those people working for free, so-called free, in the apprentices, platform work, they do not enjoy any legally known positions. So what to be done is just necessity to change their legal position with nobody still working, but I mean, it's really difficult to classify them, and to the certain regulated by the EU states legal position. Marginally, I am in this paper only wonder why do they work at all? I mean, I understand the problem, because majority of them, at least in Poland, but also here, I would say those Uber Eats, and here is called in Spanish Glovo, I noticed this today, I would say, they are not Spaniards, that's quite normal. They are not Polish in Poland. So they are doing some kind of the work, I would say, because they need to get some money. And I am trying to simply to present, I would say, this concept of the no legal regulation whatsoever with the traditional concept of employment, subordination, and if there is some kind of the exchange, I would say. If we are workers or employees, I would say boss doesn't matter, I would say there is a kind of the subordination, even if you are working at the university, to the special position. I mean, it's not like a position from the 19th century in England, I would say in British labor law, master and servant, but still, I would say, I have a boss, the director of the institute. I have a boss, I would say, Father Dean. I have a boss, Reverend the rector of our Jesuit university. Still, that I am subordinated to a certain extent. Technically speaking, I would say, those people who are just simply performing the type of the work, technically speaking, they are not subordinated to nobody. They are working for themselves at all. But they are working in the terrible type of the employment conditions. And I'm going to elaborate. But first, I'm going to, because it's a relatively new idea, I would say, developed since a couple of years ago, brought by the so-called fourth industrial revolution, which is happening around the world. So definition, what we are talking about here? The different terms I used here. Sharing economy, most elegant, I would say. Everybody would like to share something which is, has an entrance to a certain extent with the other people who are in need, particularly. And platform economy, gig economy, I would say, I just wonder, I was just trying to get, I would say, what's this word gig? It's an American slang. It's quite normal, I would say. The gig, there's a short number, I would say, in the Harlem, I would say, in the Apollo Theater, I would say, in the Harlem. Application-based type of work. And who are involved, I would say, so the stakeholders here. There are three parties are involved in this work concerning the performed on the online platform. Clients, platform, and the worker. So the workers, they are under the legal obligation to carry out special tasks. We are not going about the work. It's done on purpose. We are talking about the task. Work is outsourced and contracted out. Jobs are broken down from the position of the work, I would say the process of labor, to the different task. That's the whole concept. The next issue is about the employment status. Now, they are being classified by the different EU governments as either self-employed, student workers, maybe some of them they study, but it's retired people who are strong enough, I would say, to get additional money for living, and definitely speaking, unemployed people. And also, occasionally, in some EU states, they don't have any legal status. That's not regulated, I would say. The employment status is not regulated. Wages, very low, unpredictable, irregular. That's the most important thing here, is just the word irregular. Some of them, they are making, I would say, fantastic amount of money, I would say. The high-class specialists, I would say, designers and so on, but only some. Risk. All type of the occupational risk is just simply brought upon them. There is not whatsoever responsibility of platform work or client of this platform for any wrongdoing by the worker. Possibility to attend the training, very limited, and there is, practically speaking, no opportunity for skill development. Working time, limited rest breaks, unpredicted working time, higher work intensity, and allocation of tasks by algorithm. Discrimination and harassment, either by client or algorithm programmed by the platform, by somebody who is running this particular platform. There is a myth, the next issue, about the self-autonomy. So self-autonomy is ability to manage time work in flexible way. But riders, for example, can choose the shifts, place the work, and also can choose how they decide to deliver of food or something, I would say, they are delivering. Control. There is control via notifications. I would say the platform is strictly controlling using the electronic devices, I would say, all functions performed by those workers. Accept the order, arrive to the client, collect the money from the client, report, I would say, to the platform boss, delivered. And I mean, the boss, platform boss, which is not employer officially, could strictly monitor the whole track. So electronic ratings, then they are also under the critics of the clients, because the clients do rate the quality of the services. And it depends, I would say, their career on this. So the number of platforms in Europe, 613 in the years 2015, 2018. So it's rather old, I would say, but nobody knows so far. Share of platform workers among the workers on the labor market. Not very high, I would say 2 to 6%. Type of activity, I would say they are performing. Food delivery, taxi services, Uber taxi, Uber Black, I would say, if somebody would like to go to the limousine, I would say, to the airport, for example. Consulting. Even the lawyers, I would say, to the next future, they will lose their type of work because just to give the legal advices, they will be repeated by that. And transport. Transport is the most important thing. And the Spanish court, quite recently, last year probably, decided, I would say, that there is a service. They are not employees, I would say, their service performed, I would say, in the transportation. Main reasons for rise of the platform work. First, need to cope with short-run fluctuations on the demand side. Second, desire to reduce labor cost. That's the issue here. It's all about this, I would say, that those businessmen, entrepreneurs, they would like to cut the cost as much as possible, labor. And the third issue, urgency to meet market pressures and the short time results and efficiency. Who are the workers? Runners, riders, taskers, clickers. They are humans between the digital carton delivering services managed electronically. That's the issue number one of the work condition. The second one, problem here, the major shorter, is about the regulatory issues. As so far, out of the 28 states of the European Union, only 3 of them, France first, Italy, and Denmark, only partially regulated, I would say, the status, legal status of those workers. France, the law from 2016, there's the definition, electronic platform is understood as a company that, irrespective of its place of establishment puts into electronic contact a client and worker with the purpose of selling or exchanging a good or services. So I'm technically speaking from the legal point of view, we can talk, say, okay, we don't want to classify this platform as a worker, but definitely is there intermediary, I would say, just to sending somebody to work and giving him a chance, I would say, to work. The act applies only to self-employed platform workers. Doesn't apply to the workers, the regular workers. Even the charter applies to self-employed, and France ratified revised charter. The platform must determine the main features of the good or services exchanged and set a price. And the last issue here, the French Act provides platform with voluntary system of paying social security contributions for their workers. But remember, there is only possibility and is a decision made by the platform work, whether or not to contribute in social security dues for the worker. In Italy, there is an Act of 2017, there is a protection of workers against unfair practices of platform work, other workers and clients. In matters of non-payment of wages and protection of maternity. That's the only two issues. And Denmark, quite recently, there is a guarantee after somebody is working for at least 100 hours, and such a person could receive the minimum wage. The minimum wage, which is higher than the minimum wage, because it's just equal to the average wage in the country. So, what's the response? We have to react somehow. So far in Europe there is no reaction. So what should be done? Platform business must comply with the first issue, relevant national laws and European standards, those which I presented. Employment status of platform workers which are dependent should be recognized. They are dependent, I would say. They are being directed by the, practically speaking, electronic system. But electronic system, I would say, some as artificial intelligence, it was presented before, and doesn't work. I mean, somebody is just introducing this, introducing and using this particular system. The workers who are truly not self-employed ought to enjoy the right to organize in the trade unions and to bargain collectively over terms and conditions of their employment. Workers, regardless of their legal status, must receive at least the minimum wage in their jurisdiction, in their country or their area. They are just simply working. Access to social protection in case of the unemployment, disability, insurance also, health protection, pension, the old age pension, illness, in case of the illness, industrial injury and maternity benefits. They are standard, I would say, procedure as far as the social security law is concerned. Why I am presenting this? I didn't develop it. I'm just simply referring to the Frankfurt Declaration from April 13-14, 2016. According to this, platform act as a labor broker. De facto, all platforms are employers. De jure, clarification of both platforms and workers is necessary in such matters as basic working conditions such as wages controlled by the workers. So now workers are classified as independent contractors, but controlled by the employers. So conclusions. I have already those 5 minutes. Just conclusions. So the platform works which are in practice dependent employees must be classified as regular employees. Workers not controlled by platform should be classified as self-employed, which are not controlled, technically speaking, by the platforms. However, self-employed must enjoy the certain standards and labor and social rights, human rights. So this charter, directly speaking, that in order to the self-employed the rights. And at the end, I show, I would say, some poster, which I showed, I would say, to Polish colleagues, which is written in Polish, but I will translate it. But the poster is copied from the old American poster from 1946. There is a Rosie, and I would say she's showing that we can do it. So we can do it, I would say, some kind of the idea, motto of this, the trade unions which brought it. And also it's some kind of the cliche here, especially for the Polish readers. I would say such a jest as this Rosie is using, it was shown in the Olympiad, remember I would say in Moscow 1982, by the Polish high jumper, I would say, from this point of view. So we will survive for first, and we can do it, and we'll succeed. So this is the idea of that particular poster. Thank you very much.
Thank you very much. Last but not least, Elena again is going to present another paper that she has written with Reginaldo da Mota Correa de Melo from the same university, from Amazon University in Brazil, titled The Effectiveness of Budgetary Public Hearings on the Definition of Priorities of Public Policies on behalf of the accomplishment of social rights. Thank you very much.
Thank you. Hello again. This is another research of mine and Reginaldo. And we are talking, we are researching about public hearing. Public hearing, the focus of this work is observe the public hearing like an instrument of popular participation. So this is participation theory, okay, in management or public management and law, interface law. Like an instrument for concretize or secure the Article 6 of Brazilian Federal Constitution. That includes education, health, alimentation, work, housing, transportation, leisure, safety, social security, protection to maternity and childhood. These are our social rights in Constitution. So we have to transform or make the public hearing as an effective instrument to popular participation. In this case, we are public hearings like instruments, such as instruments, but we have specific budgetary public hearings. In case of budgetary public hearings provided for by the Fiscal Responsibility Law, Complementary Law 101/2000, it configures the preliminary consulting to society in which its concrete actions are weighted in the most diverse areas of action of the public power. So if you have money and you have a money linked for the decisions of participation, of popular participation, we can guarantee social rights. Obligation and effectiveness. Why I point this? Because it is convenient to highlight that in order to legally establish political development, economic and social public policies, the Federal Constitution of 1988 has ratified that creation of budgetary pieces to implement the public expenditure system. So we have an obligation. We have a law and a norm to obligate. But the executive power, in all its sections, the executive power was obligated to hold public hearings, so the society could manifest on the creation of management public policies and the effective fulfillment of the community's necessities when creating budgetary pieces. But does a qualified debate really exist? This is a question. because we are studying a lot of these pieces of public readings, these documents derived by public readings, and you observe which there is no a good debate, a qualified debate. People don't have way to participate with qualify. The budgetary public hearings, therefore, must be analyzed for their aspects of potentiality, observing in which levels those opinion gatherings will configure a debate and the public consultation. And the public consultation has turned into an instrument of effective participation on the administrative sphere. So we have sometimes people doesn't doesn't have how to participate because don't know about the subject. So in conclusion, the accomplishment of the consultation by itself, even though listening to society's urges, does not mean that citizens have exercising the right of opinion. Okay? Since the budgetary proposal may not bring it its core, actions that show the effectiveness of concerning measures to the collectivity. Therefore, the core of association participation's effectiveness by the budgetary public hearings must build from a concrete debate. The budgetary systematic able to allow that the public financial execution concretely reflects the list of fundamental rights needed to the social welfare. So we have to improve the society to participate in effectiveness, with effectivity. Okay, so it is, and if you have any questions, I'm here.
Thank you very much. Well, I think there are. Thank you. Firstly, thank you for your very stimulating papers and presentations. I think there has been like two groups of presentations in this panel. The first two ones I think are more related to civil rights, we can say, and the third last one's more about social rights. So in my comments, I'm going to start with the first ones, and then with the second ones, and after that, well, you can answer, and we start the discussion with the people. Yeah, but after all. But well, the first one is I don't know if Pablo is listening us or
Yeah, I'm here.
okay, thank you very much. Well, I think okay. You have presented a very interesting view about how the end of resocialization of prison does not work in practical terms, because probably the most vulnerable people is the ones that finally are in prison, particularly for example, in Spain, the great number of people that are in prison is because of drugs, of crimes related to drugs and so on. My question would be, which alternatives do you find to this? Because there are a lot of literature, there are a lot of procedures about, for example, reconciliation processes in other types of crimes that are like terrorism, for example, or which are the alternatives do you find to prison? Because probably in the general view of the population, prison is still needed to punish the most dangerous crimes. That will be my question.
Well, let me start with your question is not an easy question in the sense of there's a lot of moving parts. For instance, there's no doubt that there's a section of the individuals who are behind bars who, despite treatment, despite everything that we do, they will continue their ways, and they most likely will remain behind bars. So the vast majority of the people do not fit that category. So I think that there's a couple of things I want to talk about. One of them is, I think the media plays a part in how we feel about compassion and about a solution to that problem, in the sense of stoking the fear and making people feel that the more we keep people in prison, the safer we are, which is not true. It's something that is problematic to reach a solution. The other point that I want to make is, I think that just like we do in our personal lives, I'll give an example. When I move to a new town, I find somebody who can fix my car, and I ask people around, and I might just find a couple of referrals, and maybe end up with doing something that somebody else did, or go visit somebody else in order to get my problem solved. I think that every country has to look around and see who is doing a good job at the problem that we're trying to fix. And I'm not saying adopting exactly what they're doing, because the societies are different, and they interplay is completely different. So, but let's look at what it is that they're doing, and maybe take that into account as we search for an answer. I'll give you an example. I think one of the most talked about ways to deal with incarceration has come out of the Nordic countries, and it has been discussed a more humane part of seeing crime as a society problem and not as them versus us problem. I'm not suggesting that's a solution, but it's probably something we should look into it. And for instance, in Spain in 2015, there was the equivalent of life in prison with parole, the prisión permanente revisable. And here in the US, we have done that quite a bit, and I'm not suggesting that it won't work in Spain, but the prospects without any kind of rehabilitation are grim. So I think in answer to your question, I think we have to have we have to look around for a solution in other places where they have come up with something better than we have. And B, we have to be close to the proximity of the problem. I think if you have a person, a family member or a friend or somebody who has been behind bars, then you have that proximity to tell you maybe what we're doing is not going to fix the problem, so we need to do something different. So those are the 2 points I have for you.
Thank you very much. Tomasz, well, I agree with your presentation or with the arguments you have offered and you have argued. Well, in Spain, for example, we have had the experience, because we was one of the first countries that approved the same-sex legal marriage. But the Conservative Party goes to the Constitutional Court, and finally the Constitutional Court makes a very interesting interpretation with sociological argument, I think, trying to adapt what in the mind of the fathers of the Constitution probably there was not, but they adapting to the reality of Spain in 2005. Do you think that there is some difference between, I mean, Poland, like Spain, are Catholic countries, in majority Catholic countries, do you think there are some difference in the way the Constitutional Court, for example, can take into account this type of arguments with this? Because finally the problem is a religious problem, no? More than other type of problems, I don't know. So do you think that is the problem, firstly? And secondly, do you think in Poland, for example, as a Catholic country like in Spain, you can arrive to the same solution that us?
Finally, you accepted this.
Yeah.
Yeah, of course. Okay. Well, I think it was the two questions. So the first question I see is concerning the verdict of the Constitutional Tribunal. Well, I said that in 2004 the Constitutional Tribunal evaluate the constitutionality of the European Union access treaty concerning also the Poland, and there was the accusation, there was the application that general prohibition of the discrimination from the European law is not in consent with the Article 18, as it prohibits the same-sex marriage. The Constitutional Tribunal stated that in Poland there is Article 32 that also prohibits the discrimination, and but still stated that the Article 18, the change of the character of the marriage, will require the amending the constitution. So I don't think that generally the constitutional or the courts generally establish some line of the verdicts. So I don't think it could change its verdicts, especially because of the very clear, for example, historical material, that this phrase man and woman was simply introduced to limit the marriage only to the heterosexual couples. So I don't think that Constitutional Tribunal will change its line of the judgment, especially because in general I think our Constitutional Tribunal judges are more or less conservative. Some very radical conservative and some are moderate conservative, but I think still they are conservative. So what could happen? Maybe we will, the approach of the society will gradually change. I think what's the difference between the Spain and Poland? I think it's the difference of some, I'm not sure, 20 years or something, because it's the time of the democratization. Because we start the democratization, the transformation from the 1989. So the transformation not only concerns the economics, the law, but it also concerns the culture, as we are getting similar to the Western societies. And we just started the process. So I think if there will be the change will come from the society. It would be rather similar to the Ireland, when suddenly it was shown up that people are ready, and if there will be introducing the same-sex marriage, I think that it will be decided in the referendum when there will be a majority of society supporting it. But you know, but if it happened, and when it happened, or eventually when it happened, well, it's really hard to tell. Okay, so that's my answer.
Thank you. Well, and now I'm going to make some general comments for the social rights core of the presentations. I think, in the three last presentations, you were talking about working conditions. You were talking about participatory, also in the guarantee, in the way of guaranteeing social rights and so on. Well, the first one, I think neoliberalism has radically changed jobs nowadays, and your paper present how the precarity, not only in the new apps that works now, but also precarity in other works like lawyers, as you explained, is the reality in our economies from the crisis of 2008, but probably in general. No? We have increased the precarity in the working conditions, and we have reduced labor rights, although probably the laws and the laws of the different, for example, European countries still recognize labor rights. But in practice, we know that these labor rights has been cut, has been reduced, and has been reformulated. So the question is, are these labor rights adapted to these new realities of new technologies, new apps? How can we save the position of the worker? For example, when you talk about slavery, maybe if we think about an universal basic income as a way to guarantee a minimum decent condition of life, of living for everybody, can be a way to be a stronger the position of the workers, or is enough to trying to translate the traditional labor rights to the new working conditions and to the new working relationships? Because I have the feeling that probably we are using tools from 20th century trying to apply to a new reality that we don't know how it works at the end, and that we don't know how is going to be working in 5, 10, or 15 years. No? It's very difficult to make predictions in this field. So maybe we have to think about another way to guarantee the right to work, the labor rights, and maybe I propose maybe one option can be an universal basic income, for example, as some people propose. And the last point, when you say about the participation in the budget, and I think it's a very important thing, because probably one of the reasons of the crisis of the welfare state is that there was not enough participation from the citizens in the ways or in the decisions about how to guarantee social rights. But what happens when people is not interested in participation? Because we see that, for example, in the participation budgets, that there is a very low number of people that participate, that vote those budgets and so on. And in addition, maybe we need some type of procedure a better procedure in the way to implement the participation in the way to guarantee social rights.
Both questions are two challenges and difficult challenges, I think. But in the case of contemporary slavery, is more than labor rights, I think, because it's exploitation. There is no minimum of guarantees. No minimum. It's different about and this is the speech of opposition of the discuss of the big companies is say that it's only a break of labor rights. And it is a question of human rights, do you know? I think we have to make this difference between dignity and the labor rights. It's less. So in Brazil we are walking in a slow way to guarantee the minimum. This is the problem. So it's a big challenge. But I think contemporary slavery, if you look for, you find in all countries, do you know, like traffic of people, do you know? I think it's a result of capitalism, but I think there are it's not the same labor rights and the contemporary slavery. We have to do dissertation. And in the case of participation, in Brazil, in context of Brazil, in context of my state, Pará, in Amazonia, we have to make a difference because people, they are interested to participate, but they are not prepared to participate, do you know? I think education and we have to construct a method, a good method for educated to prepare people to participate because they don't know how to participate. Do you know? I think in Brazil things are very complex because of this, because it's I don't remember the word. Missing. It's missing education. It's missing. Even people want to participate, they don't know how to do this. So this is my answer.
Okay, I must say, to a certain extent, there is a paradox. 100 years ago, International Labour Organization has started. And 75 years ago in Philadelphia, it was a main motto of that organization. Labor is not a commodity. So you have to start from this perspective. And John Paul II, the Polish Pope, if you will study his works, you will understand that, I mean, the labor is something more, obviously not a commodity, and obviously there is not the electronic device used, I would say, nowadays by the platform work just to control those persons who are performing the work. In Poland, there was always, I would say, the distinction between work regulated by the labor law and, let's say, between the great wars, I would say, the labor law as a separate discipline has started, and the work regulated by the civil law. So there is just a possibility, and obviously, I would say, there is some kind of the exchange. There is a special feature of the labor work is based on the idea that we are subordinated to the employer, and the employer is under the legal obligation to take care of our needs and our interests. But in Poland, I would say there is a choice between the new way and the old way, but it's really necessary to make sometimes a certain distinction between the category of people we are talking about. Let's say the millennials. They are not so ready to accept, I would say, any type of the work. They have certain demands, I would say. Free time for them, for their family, is much more important just to the long time employment. When I started to work, it was in the end of the 60s, Poland was like a Japan. I was employed as an assistant by the Jagiellonian University, and I went into retirement a couple of years ago as a full professor. I would say I couldn't get any better position anywhere, I would say, for that. So it was the kind of the long life employment. Nowadays, it's different situation, but it's different situation only in the certain category of the society. There is another thing. I would say this type of work we are talking about, which is not regulated, is performed to the great extent by the unemployed people. They don't have a chance to get into the labor market, so they are taking what is possible, I would say. But Poland enjoys, I would say, the very low unemployment rate. According to ILO, it's like a full employment. I would say slightly more than the 5%. So from this point of view, I would say that would be no, I would say, pressure upon the government to protect the rights of the workers. You have to take into consideration, this is really quite interesting, that the Polish labor code was introduced into the legal system in 1974 under the communist system, and still survives under the completely different system. But it's not a, I would say, some kind of the news. Because when Poland, 1945, was invaded and was under the, I don't want to offend you, I would say, our Russian colleagues, professor, I would say, under the custody to a certain extent, or it would be the good, maybe terminology, diplomatic, I would say, for some time. So from this point of view, the law, which were simply passed by the Polish parliament between the Second World War, it was a capitalist system, completely different, I would say, political system, survived until 74. We are talking simply from the technical point of view about the good legislation. Doesn't matter, I would say, which system, I would say, we are now, but still is based on the certain provisions of the law. So it's really difficult to predict. Definitely speaking, I would say, you have to take into consideration that the certain similar, a very simple type of works wouldn't, I would say, those people which are performing this type of the works, they wouldn't lost, I would say, them. They are, because it's too expensive to exchange robotics for people, I would say, which are digging, I would say, something. No way, I would say. So I agree with Oscar what said. That's the education, vocational, I would say, in this sense, vocational education is just simply just the chance to survive. I mean, for us, it's also quite important, but you mentioned, I would say, 2008 and some kind of the crisis in Europe. But according to our Prime Minister at the time, and right now the President, I would say, so-called President of the European Union, Mr. Tusk, the Poland was the green island at the time. We are in the very lucky situation, and nothing, I would say, affected our economy, particularly at the time. It is not, from the economic point of view, definitely certain type of the jobs will be simply exchanged with some kind of the robotics time. As I said, when I said lawyers, I was talking about I stand by this particular statement, but I am talking about the very simple type of the matters, I mean the legal matters. Notaries, exactly the same. I would say, in order to make a very simple contract, even the employment contract, you don't need a legal education, definitely. So you could also simply introduce, I would say, artificial technology in this particular situation. So from this point of view, the only possibility to survive and develop even is just to educate, vocational education, to give a chance to rise, I would say, in their professional competences from this point of view. That's it. But I really don't know what's going to happen. I am quite lucky because probably I won't survive, I would say, until the fourth revolution, industrial revolution, it will be completely introduced into our system. I am too old for this.
Thank you very much. I think we have around 10 minutes to questions. So I don't know if there is any question in the...
Mm-hmm.
Hello.
Yeah. No.
Do you hear me? No? Hi. Maybe not with the microphone. Okay, but my question is for Professor Andrzej. First of all, congratulations to all of you. Thanks for your lectures. And thanks to Professor Perez for his work on this encounter. So, Professor, I have a question. This morning, there was 1 or 2 lectures about internet and how it is, the censorship has passed from government to private companies. And in this case, in the applications like Uber and all that you mentioned, clearly we need more regulation. How can we harmonize these two contradictions, this paradox that you mentioned? Because we need to regulate, but if we regulate, we contribute to more censorship of the internet because these are apps that are based on internet. What do you think about it?
I am really not an expert on those modern devices to manage the people, but I mean, from this point of view, it would be quite normal to introduce this new technology into employment relationship, not only to some kind of the, I'm saying, kind of the nothing, I would say, because technically speaking, this platform work simply denies any type of the relationship between the performer of the services and the platform. I would say there's no relationship whatsoever. There's only for one major reason, as I said, because, I mean, the system is too tight. The labor law system is too tight. So from one point of view, the system needs quite kind of flexibility. But for another thing, I mean, still, if the state is under the legal obligation to provide, I would say, some guarantees concerning the labor rights, and also the situation, not only in Poland, but in all Europe, I would say, is dramatic to a certain extent. Let's say is the social security dues for old age unemployment. In Poland, there is more than 50% of the population is over 60. And we had a problem a couple of years ago just to decrease, I would say, the retirement age from 67 to 60 for female and to 65 for the male, white collar, blue collar employees, doesn't matter. So from this point of view, we need some kind of the consensus between the trade unions and the government. And I mean, mostly employers, because right now the government is not an employer like under the communist system of the 90% of the economy in Poland. I mean, right now, however, there are certain paradoxes. Couple of days ago, I mean, the major general strike of the teachers was stopped, suspended, I would say, until September. But I wrote an article about this and even said I was quite surprised why the trade unions of the teachers decided to start the collective dispute with the government. the government is not an employer of this, of those employees. Even when we are talking about the employees, schools run by the state. The employer, technically speaking, is somebody who is directing this particular school. But they are simply started and still is some kind of the quite extraordinary situation. But from this point of view, I would say that must be some kind of the consensus between so-called social partners and with the government to the certain extent staying aside. I mean, as far as the industrial relations are concerned, I would say the old proverb of the good Lord, probably Ben Franklin in the United States, he said, the less state, the better, I would say, in such a situation. So probably, this is just simply must be regulated by some kind of the consensus between social partners, trade unions and employers organizations. I don't know how they are going to do it, but difficult to say. I don't know.
Any other question? Well, yes. Thank you very much for your exciting presentations. And now we have 15 minutes to take a coffee, and after that, the panel about political rights. Thank you very much.